now that we've looked at every part of the crime scene and what to do, we're going to look at what happens when you go from the crime scene to the courtroom. So the U.S. Constitution was signed in 1787, and it set up the executive, legislative, and judicial branches of the United States government. In 1789, 2 years later, they added the 10 amendments to the U.S. Constitution. Those 10 amendments are called the Bill of Rights. So here are all the Bill of Rights. And the one we're going to look at is number 6. It is, in all criminal prosecutions, all accused shall enjoy the right to a speedy public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against them, to have compulsory process for obtaining witness in his favor or her favor, and to have the assistance of counsel for their defense. So the Sixth Amendment ensures that a person will be tried by an impartial jury of his or her peers. The jury listens to the arguments by both defense and the prosecution, and it hears information about the physical and circumstantial evidence, and hears testimony from witnesses. The jury uses all the information to make an informed decision about the guilt or innocence of a person on trial. The jury is instructed to assume that the defendant is innocent until proven guilty. Do you think jurors should follow these instructions 100% of the time? Can you possibly think of an example when jurors didn't or did follow these instructions or did not follow these instructions? So what you're going to do today is you're going to research on Kaylee Anthony. Don't mistake that for one of the other Casey Anthony's. We're looking at the Kaylee, C-A-Y-L-E-E, Anthony trial. So as forensics has continued to evolve, the following processes have been on the receiving end of scrutiny. This is what the defense really goes at: how it's being processed, what type of evidence is admissible in court, the equipment used to analyze it, and who can testify as an expert witness in court. So there's a couple cases that deal with this. You've got the Fry versus U.S. and Dober versus Merrill Dow Pharmaceuticals. These are two influential cases that resulted in major changes in the field of forensics. So we're going to look at these two on the Venn diagram. So the first, you got the Fry standard. It originated with Fry versus U.S. And this is one about the lie detector. So this is looking at the processes, what is analyzed. So it states that evidence must be accepted by the scientific community before it's admitted in court. If it's not accepted by the community, it's not admissible. And it relates to evidence. Big thing, evidence. So the Dauber, that was in 1993, it was a ruling that allowed the trial judge to make the final decision saying who is an expert for the expert testimony. This one is expert testimony. So Fry is evidence, Dauber is the expert witness. So both are standards that govern what is admissible in court, and then they must both be accepted by the scientific community. Both recognize that science changes. So one of the things you could bring up is like astrology. Well, it's not exactly accepted by the scientific community, so an expert in astrology wouldn't go through. All right? All right, so the Dauber ruling paved the way for the use of expert witnesses in a criminal proceeding. In this trial that you're going to look at, the Casey Anthony, an expert witness was allowed to testify on his thoughts on the proposed decomposition of the trunk of the car. So we're going to watch it real quick. After this lovely little commercial, which I really hate commercials.
Based on your experience, is the stains from decompositional fluid easily distinguishable? Yes, they are. Okay, how so? What? Anyone with experience around decomposing bodies of this nature will generally be able to look at it, smell it, and determine if it's from a decomposing body or not. There are also relatively simple presumptive tests, chemical tests that can be done. Have we finished eliciting the opinion from the witness? Because it seemed like we stopped. Obviously, he's not qualified to talk about phenolphthalein tests. We've already heard from an experienced serologist about that. So clearly he's not qualified to testify about that, and that's not in his deposition. But is there any other opinion counsel's going to elicit? Because, I'm sorry, I'll wait. Counsel's busy texting. Is there another focus? I don't know how many times, and I'm not going to say this again. I do not want to hear editorial comments. All I'm concerned with at this time is the proffer and whether or not was in his report versus his deposition is a violation of this court's order. I do not care if Mr. Baez is standing on his head, standing on one leg. So, folks, please, let's just stick with the facts and be professional. When a body decomposes, if a body were to decompose in a car, what type of fluid, what would the, let me see if I can pose this question correctly. What would you expect to see a day or two from the decompositional fluid? The decompositional fluid that leaches from the body has a blackish staining.
Okay, so that's about it that I'm going to show on that one. Should he have been allowed to testify as an expert witness the way he was? Looking at the bottom, this guy's a bug expert. Should he have been allowed? All right. So additionally, we have a hair expert that was called as an expert witness, in this case to provide information. We're going to watch a little bit of that. Let's see if that one should be allowed.
Can we use your home to showcase one of our new
After
styles or colors? We need
the darn
ones of all shapes.
ads.
The previously reported Q12 hair, Caucasian head hair exhibiting characteristics of apparent decomposition at the root end exhibited the same microscopic characteristics as Caucasian head hairs from the hair mass. Accordingly, this hair and the hair mass are consistent with originating from the same source. However, it should be noted that hairs are not a means of positive identification. In other words, I cannot say that a hair did originate from a person to the exclusion of all others. I can say it is consistent. I should also be noted that the hair mass itself is not a suitable known hair sample. In other words, I did not have hairs plucked from an individual scalp, from a known individual scalp. We can't determine that a hair is from a child or from an adult. Depending on the age, sometimes the hair can be thinner. Sometimes the cuticle can be thinner, but we can't say that hair came from a child by examining it or an adult. I don't know the source of those hairs. The hair that you observed in this case, the Q12, the one we saw the photograph, you testified that when you got the Q59, which was the hair mat from Suburban Drive, that the characteristics were not similar. I did not do a side-by-side comparison of the root portions, but the hair from the trunk had root material below the band. The hairs in the hair mass had a dark band just above the end of the root, but it had more of a brush-like, what I would classify as a brush-like appearance to it. So it was a different appearance.
So just looking at that, do you think him as a hair expert, was he appropriate for this situation? I'll let you figure that one out on your own. So looking at this, we have the court proceedings, how everything goes. So you have a suspect that is arrested. Then they are arraigned before a judge. And whether they are put into jail for holding or whatnot, that is up to that right there at the arraignment. Then you have the discovery. This is where all the gathering of all the evidence is put together for the lawyers. From this, you could get a deal, and it can be offered or accepted. And if it is accepted, then you get a conviction right off the bat, and then you get sentencing. But if the plea deal does not go through, you have a preliminary hearing. And this is where the judge rules if evidence is sufficient enough, if he accepts it using the Freien-Dauber, who can be the witnesses and whatnot. And then you have the trial, and then you have a jury by deliberation. So they can either say if they are guilty or not guilty, acquittal, and if there's an acquittal, the defendant is released. If they are guilty, you got conviction again, and then sentencing. Once they get to that part, you can have an appeals process, and sometimes there's lots and lots and lots of appeals. All right, so I'm going to be done for the notes for today. What I would like to say is if you are interested in this section, next year, Mr. Dwyer does criminal justice, which means you guys could go to his class and learn about this process in the courts. All right, so that's it for today for this. Don't forget to do the research on Kaylee Anthony. You did see a little bit of it, of Casey Anthony in there. That was the mother. Besides that, I hope you guys have a great day. Let me know if you have any questions. Email, class, tag me. Don't put comments in. I don't read comments. And this is the first thing that will end up going on quarter 4. Besides that, I hope you guys have a great day.